Thank you, Jonathan. I promise, I covenant, I undertake. What exactly do these expressions mean? Is there any difference between them? On the surface and in general use, there would appear to be very little distinction between the three terms, and we would all associate each reference as preceding an obligation on a party to do something or to refrain from doing something. However, there are some subtle differences between the three, and this presentation shall look into what these differences are and whether such differences can have a practical effect on the interpretation of contractual clauses, going beyond a mere academic distinction, with the intention of identifying whether the phrases I promise, I covenant, and I undertake can make a difference in legal drafting. In addressing these subtle differences, I shall also look at some specific areas where a promise, a covenant, and an undertaking will have a particular meaning. Naturally, in preparing this presentation, my starting point was to reach for the dictionary, which provided me with the following definitions. A promise: the manifestation of an intention to act or refrain from acting in a specified manner. A binding promise being one that the law will enforce is the essence of a contract. A covenant: a formal agreement, historically in a deed, which is meant to be binding on the party. In finance law context, also known as an undertaking. In property law context, in some circumstances, may have to be given in a particular form for it to be binding. Finally, an undertaking. In finance or property law, in some cases, a formal legally binding agreement or promise to do or provide something, or to refrain from doing or providing something. According to the legal definitions, a covenant and an undertaking are the same thing, at least in a finance and property law context, and they both mean a legally binding promise. Therefore, we might conclude that a promise, a covenant, and an undertaking are basically all interchangeable terms. But can this be correct? As stated, a promise is an expression leading to another person to expect certain conduct on the part of the promisor, and a promise will create a legal obligation on the promisor. Furthermore, such legal obligations can be express or implied and do not have any formality attached to their construction and can be verbal or written. The scope, therefore, for a promise being made is potentially wide if we include implied verbal expressions. When I tell friends to make themselves at home when visiting my flat, I certainly have not intended to make an implied oral promise, granting them a legally enforceable right to redecorate the walls and to change the locks. Of course, the difference here is that, amongst other things, there is no intention to create legal relations and no legally binding promise has been made. So that is a promise. What about a covenant? Again, a covenant will create a legal obligation, however, is more formal in nature, partly due to a covenant having to be made in writing. Although no particular words are necessary to make a covenant, it must be clear that the words are intending to operate as an agreement, and not merely as words of condition or qualification, and that such an agreement intends to bind the person giving the covenant. For example, using the words such as "the parties agree" will clearly be evidence that there is an agreement, whereas if there is no obligation, whether implied or express, no covenant will be deemed to have been made. Historically, a covenant was a form of promise, which was made under seal or by deed. Why was a seal or deed required? Because traditionally, a covenant was a form of one-way promise, rather than a mutual agreement. So only the covenanter could break the covenant, and the person receiving the covenant did not have to provide any consideration for such covenant. That definition has broadened over the years, particularly with the dwindling role of seals, and indeed the reduced use of deeds in a business-to-business context, unless there is a genuine absence of any consideration. So that now a covenant can encompass a promise made in writing, made in a written agreement, where either the covenant specifically or the agreement generally is supported by consideration. However, we still see covenants being specific to restrictive covenants, which restrict the way a party can act. For example, in a property law context, the way in which land can be used, or an employment contract as to what an employee can do. However, could those specific covenants be framed as undertakings instead? There is no reason why an employee's restricted covenant could not be worded as the employee undertakes that he will not compete for the business of the employer for a period of 6 months following the termination of his employment contract. Similarly, there would be no difference from stating a full title property covenant by agreeing the seller undertakes that the property she is selling is free from all charges, encumbrances, and adverse rights. So are there any differences between a covenant or an undertaking? We have already seen from the legal definition that an undertaking is a formal promise that creates a legal obligation, and in property and finance terms is synonymous to a covenant. An undertaking traditionally meant a written promise which was offered as security for the performance of a particular act, hence a solicitor's undertaking or an undertaking in relation to legal proceedings. And so, like a covenant, traditionally an undertaking was a form of one-way promise rather than a mutual agreement, and the action for a breach of undertaking was an action for a breach of promise rather than an action for breach of contract. Hence, no need to prove offer, acceptance, consideration, etc. to establish the undertaking. However, these days it is not necessary for an undertaking to be strictly written, and like a covenant, a deed is no longer required. Does that expression of "I undertake" have a more distinctive meaning? After all, it is a term that is also used in some specific situations. For example, a solicitor's undertaking. A solicitor's undertaking carries certain professional obligations for the solicitor, because breach of a solicitor's undertaking is a matter of professional misconduct, but it is still no more than a promise by a solicitor to do something, and there are no limitations implied by the use of the term undertaking as to what that thing might be. It might range from paying out monies to delivering documents, and certainly if you were the recipient of a written document from a solicitor which said, for example, "I promise that upon completion of the sale I will pay the sale proceeds to you," you would not expect to meet the argument that this was not a solicitor's undertaking simply because the word undertake had not been used. And again, the expression undertaking is used in a wide variety of situations which have nothing to do with either finance or property law contexts that the legal definition may have suggested. So, for example, court proceedings might be settled on the basis of certain undertakings being given to the court itself. So, the key conclusions from my review are: all terms create a legal obligation. However, a promise can be, perhaps due to historical reasons, less formal. A promise and an undertaking can be oral or in writing. Covenants and undertakings are both forms of promises, but traditionally a covenant has to be in writing. There are historic differences between promises, covenants and undertakings, and there remain circumstances where one expression is traditionally used rather than the other, such as a restricted covenant or a solicitor's undertaking. As most of the agreements we will deal with today are written ones, there would in fact be little or no difference in their application. So, to answer the question I posed at the outset, in a commercial contract, whether there is a difference if one says, "I promise," "I covenant," "I undertake," or simply, "I shall," should not make any difference at all, and the choice of certain expressions in particular situations is simply a matter of legal convention. And with that, I'll pass you back to Jonathan. Thank you.